So here are some examples of critical stage proceedings. It is clear that whether these happen before or after indictment, that a person has a right to counsel at these proceedings and in order to prepare for them. These are interrogations after the Article 1517 hearing. Again, that could be before or after indictment, lineups, examining trials, psychiatric exams, plea negotiations, and then I think the things that people more commonly think of as criminal stages, such as arraignment and trial. We can also look at how quickly must a defendant be given a lawyer after the Article 1517 hearing under Texas law. As you all know, the Fair Defense Act puts certain time limits in law for making appointments. And this is the sort of the main time requirement that you guys are familiar with for defendants in jail, where defendants have to be given a lawyer within 1 to 3 days. I think what Rothgery looks at, though, is this language, and if adversarial judicial proceedings have been initiated against the defendant. Before Rothgery came out, I think everybody sort of assumed that somebody in jail was getting a lawyer within 1 to 3 days. But Rothgery specifically looked at that language, well, when are adversary judicial proceedings initiated? And they answered that that's at the 1517 hearing. So now when you're looking at your time limits under 1.051, there's at least a strong argument that that language should be interpreted in terms of what the Supreme Court has said is the moment when the right to counsel attaches and when adversary judicial proceedings commence. I think most jurisdictions are giving defendants in custody lawyers within 1 to 3 days, so I actually don't anticipate that Rothgery is going to have a tremendous impact on how quickly defendants in custody receive counsel. I think most jurisdictions are already doing that. I think it's when we look at how quickly must a defendant be given a lawyer if they are released on bond that we may see the biggest impact looking at how Rothgery will affect how local jurisdictions interpret the Code of Criminal Procedure, and particularly Article 1.051J. So that provision says that notwithstanding any other provision of this section, including the 1 to 3 day provision that I just had up there, if an indigent defendant is released from custody prior to the appointment of counsel, under this section, appointment of counsel is not required until the defendant's first court appearance or when adversarial judicial proceedings are initiated, whichever comes first. So per Rothgery, we know that adversarial judicial proceedings are initiated at the time of the Article 1517 hearing. And in fact, in a footnote to the Rothgery opinion, the court suggested that it sees the initial appearance before the magistrate as also being the first court appearance. And that's one of the early footnotes in that decision. And so I think counties really need to look at how they are interpreting this provision of the law and whether what the practice conforms with what the Supreme Court has told us about when adversary judicial proceedings commence in Texas, which is at the Article 1517 hearing. Many jurisdictions, I believe, do have policies similar to the policy that Gillespie County had of waiting until indictment to appoint counsel for defendants released on bond. And those are procedures that I think need to be re-examined to see if they are consistent with what the court said in Rothgery and what Texas statute says are the time limits for providing counsel. These are some suggested best practices for appointment of counsel after Rothgery. And basically it just involves treating jail defendants and bond defendants essentially the same. So the time frames that you are currently using for jail defendants, I know a lot of counties now are just putting bond requests to the side, pulling the requests of people released on bond and just not dealing with them immediately, oftentimes not dealing with them at all, just waiting to see if people request counsel again later. Those are the practices I think need to be re-examined to make sure that you're not opening yourselves up to liability under Rothgery and for violations of Texas code. This is just a brief point about, there are several slides in your booklet. I think since we're running late, I may not go through them with very much detail, but these are some of the consequences that counties may face, other than somebody like me coming out to bug you, if the best practices aren't followed. It really is exposing you to some vulnerability in terms of confessions or other things that may happen after Article 1517 in your jurisdiction. And counties need to be aware of the fact that this may not, you're not really worried just about lawsuits, you're worried about how this may affect the criminal convictions, your ability to obtain criminal convictions in your jurisdiction, because this really, especially with confessions and lineups, can create situations where if defendants ask for a lawyer at magistration and they don't receive a lawyer, and someone comes and tries to interview them later, a police officer tries to interview them later, that those confessions may be suppressed if that request for counsel was outstanding and if the police did not follow the proper procedures for obtaining a waiver of counsel from someone who has requested counsel, because the rules are different. After they request counsel, the procedures that police and prosecutors have to follow in order to obtain a waiver are different under case law. So this is just an example. This is Michigan v. Jackson. This is actually the Supreme Court case that we relied on in Rothgery, which is an earlier case where the Supreme Court suppressed a confession in a murder case because the defendant asked for a lawyer in front of the magistrate, didn't receive a ruling, and the police later got a confession out of him, and that confession was later suppressed. And so, so this is really just to highlight that there are other consequences you need to worry about other than civil litigation, and also to highlight that I think an important element of implementing Rothgery is going to be making sure that local officials have common access to this information. So in Michigan v. Jackson, I don't think the police officers had been made aware of the fact that the defendant had asked a lawyer in magistration. So they didn't even know that they were supposed to follow this separate set of procedures, or that separate set of rules had been triggered. But the Supreme Court in the case law imputes any state actor's knowledge to another state actor. So it doesn't matter if your police officers don't know that a defendant requested lawyer at 1517 hearing, that knowledge will be imputed to them. And if they do obtain a confession, even not knowing that the defendant had asked for a lawyer, that confession could be suppressed. And so I think it's important for jurisdictions to look at how do you make those 1517 records easily accessible to prosecutors and to law enforcement officers so that they can behave properly and get confessions, if they do get confessions, that will be admitted into court later.